Hi, everyone. It's nice to see you all, even if only virtually. I really miss the conferences we used to have like 10 years ago or so, where we would all get together in Leavenworth or some other place in the middle of the state. And we'd go around the room and discuss the Supreme Court cases everyone had pending, as well as the other hot issues everyone was raising. And hopefully someday we can do that again. But for now, it's really nice that Gideon and OPD have launched these virtual meetings so that we can connect more frequently and at least get together virtually. I agree, that's far better than nothing. Gideon asked me to talk today about a case I recently litigated challenging the 3 strikes law on various grounds. And what I'm going to do is essentially give you guys a presentation that I gave to a law school class a couple of months ago, and I gave it again in-house to my own office. And I'm going to start by talking about what we did in Gregory, because Gregory set us up to be able to make some of these arguments challenging what is now the harshest sentence in the state. Both the data and the arguments are going to be slightly different in this context, but it's all part of a natural progression from Gregory. So it's helpful to understand that background in order to facilitate the next steps. And actually, before I launch into this, I also want to mention that this challenge not only built upon Gregory, but also built upon the great work that Jody Backlund and Manic Mystery did in Witherspoon a few years back that many of you may remember, as well as the great work that Andrea Burkhart did recently in the Smith case last year. So working together with our brilliant colleagues from all over the state can be really helpful. I totally agree with Gideon on that point. Okay. In any event, when it comes to Gregory, you all know the ultimate outcome, and it was this, in an opinion written by the late, great Justice Fairhurst, who we miss very, very much. But how did we get here? Well, in December of 2012, which I can't believe is 10 years ago now, I'm sure some of you feel the same way I do about the passage of time, Neil Fox and I were appointed to represent Alan on appeal from his death sentence. Mr. Gregory was sentenced to death for the aggravated murder of one white woman in good old Pierce County. John Neeb was the prosecutor. And actually, this appeal was an appeal from a resentencing, from a second death penalty proceeding, because Suzanne Elliott and David Zuckerman had gotten his original death sentence reversed due to prosecutorial misconduct. But then he was sentenced to death again by a second jury after a new penalty phase proceeding. The way it worked in capital cases was that juries decided the sentences by answering the question of whether sufficient mitigating circumstances existed to merit leniency. And if so, then the person got life without the possibility of parole, and if not, they got the death penalty. And then death penalty appeals went straight to the Supreme Court rather than going through the Court of Appeals. And in death penalty appeals, we had a statute that required so-called proportionality review. So it required the court to reverse a death sentence if it was not proportionate to the sentences others were receiving for similar crimes. And life without parole was the only other available sentence. So for each aggravated murder case, whether it ended in the death penalty or life without parole, the trial judge had to fill out a form with specific fields about the crime and the defendant. And then these forms went into a Supreme Court database, and they would pull them out for proportionality review each time they got a death penalty case. And the parties would argue about whether the death sentence was proportionate or was instead just arbitrary and random and unfair in light of everyone else's sentences. Now, our court never ever reversed under that statute, even though they should have. We had over 300 adults convicted of aggravated murder in Washington over the years. Only 8 to 10 were on death row at any given time. And those folks were not the so-called worst of the worst. For instance, some people like our client had a single victim, but dozens of people who had committed aggravated murder against multiple victims were serving life sentences. Some people, like our client, had little or no violent crimes in their history, but literally scores of people with several prior violent felony convictions, plus an aggravated murder, got life sentences. Some counties in Washington never sought the death penalty, even in the most egregious cases, while other counties like Pierce County seem to enjoy seeking death sentences. So there were these problems of unfairness and arbitrariness and randomness that the proportionality statute was designed to address, but it totally failed. So in any event, Mr. Gregory, again, killed a single victim, and I don't want to minimize the nature of this crime. It was a very brutal murder. Nevertheless, it was a single victim and he had no prior violent felonies, but he was on death row while scores of other people with worse histories were not. So something really fishy was going on here. So the first thing I did within a couple of weeks of being appointed was to contact Dr. Catherine Beckett, who's a sociologist, a social science professor at the University of Washington, to see if she could do a statistical study on race and the death penalty in Washington. So why did I do that? It's not something we usually do on appeal, but 3 months earlier, our court had decided the last death penalty case before Gregory. It was State versus Davis. And that case was handled by our wonderful colleagues, Eric Nielsen and David Koch. In that case, the court affirmed the death sentence, but there were 3 dissenters who would have reversed for disproportionality. Justice Fairhurst wrote the principal dissent, saying these death sentences seem random and arbitrary and not based on the crime or the defendant. You can't tell by looking at these cases who should be on death row and who shouldn't. You may as well flip a coin. And Justices Stevens and Wiggins signed on to that dissent. They agreed. But Justice Wiggins also wrote his own dissent. He said he agreed with Justice Fairhurst that the death penalty is not imposed proportionately and instead seems to be imposed randomly and arbitrarily. But he said, you know what? In some ways, it might not be so random. He said, it appears that African-American defendants are more likely to receive the death penalty than Caucasian defendants, and I would remand to take evidence on whether that disparity is statistically significant. So where did this come from? Well, Justice Wiggins reviewed these 300-odd aggravated murder reports, and what he observed when he looked through these reports was that more than 60% of African Americans who were subject to capital sentencing proceedings were sentenced to death by juries, but less than 40% of white defendants who were subjected to capital sentencing proceedings were in fact sentenced to death by juries. And Justice Wiggins didn't know if this disparity could be explained by differences in case characteristics or whether it was due in part or in whole to racial bias. And he also noted he didn't think that this disparity was due to intentional discrimination. He was willing to assume that any unexplained disparity was due to unconscious bias. But he said, look, it doesn't matter if it's conscious or unconscious, because if Black defendants are in fact more likely to be sentenced to death because of their race, then that's a problem, and it's a problem we have a duty to address. So he said he would have remanded to take evidence on this issue. But this was in dissent, so obviously it was not going to happen in Davis. Rather, he was sending a message for future cases. And of course, this demonstrates the importance of reading dissenting and concurring opinions, because that's where these messages are about what needs to be argued in the future. These dissents and concurrences are calls to action, not just at future justices, but at lawyers, because we're the ones who need to bring the claims. And you know, we're often so busy that we just sort of skim a majority opinion and don't bother with the dissent. And when there's a dissent like this, we end up regretting it. So thankfully I had read this dissent, and I was appointed on Gregory 2 or 3 months after I read it. So it was reasonably fresh in my mind and I knew what I needed to do. So the first thing I did was to contact Dr. Beckett to do this analysis and to ask her if she could do it. And I chose her because she had done some similar work in related areas. She had analyzed disproportionate enforcement of drug laws in the Seattle area. And she was also on that task force that did that preliminary report on race in Washington's criminal justice system, which has, since been updated. So I knew she was the right type of expert, and I knew our court respected her. So we met with her, and she agreed to do this, and she brought Heather Evans on board. Heather Evans was a grad student at the time, but she earned her PhD during the course of this litigation. And then the four of us worked really closely together for the next 5.5 years. And I should note also that OPD kindly agreed to fund the study, for which I was obviously grateful. I wrote a funding request letter explaining why I needed to do this, and attached an invoice or an estimate from Professor Beckett, and we went from there. So what our researchers did was to test the effect of race at a couple of different stages, and they controlled for the types of variables that are supposed to matter in determining who got the death penalty and who got life without the possibility of parole. And this is what Justice Wiggins could not do when he observed this disproportionality. He didn't know if that disproportionality could be explained by these types of factors, which are valid. Excuse me. And then one thing I want to emphasize is that we had to be heavily involved in the design and execution of this study, which is not something I necessarily expected at the outset, and not something you might expect if you embark on this type of endeavor. But we all had to be heavily involved in determining the right data set, in coding the variables and so forth, because doing this requires a great deal of legal expertise, not just social science expertise and statistics expertise. So we all did all of this work together. And, excuse me, ultimately, as you all know, our researchers performed a regression analysis and concluded that Black defendants were more than 4 times as likely to be sentenced to death as other defendants after controlling for relevant case characteristics. So that was obviously horrifying, even if not at all surprising. And so what do we do with that information? Well, with that information, plus just a review of the aggravated murder reports generally, we made several alternative arguments, which all of you, all of us always do. We started our initial brief actually led with the statutory proportionality argument, because that is what Justice Wiggins relied on to raise this concern. In terms of constitutional arguments, we argued both under the 8th Amendment and under Article 1, Section 14. Obviously, all of you well know that Article 1, Section 14 is more protective than the 8th Amendment. And strategically, you want to make a state constitutional claim so that any favorable ruling is insulated from review by the US Supreme Court. In fact, nowadays, I probably wouldn't even argue under the 8th Amendment, given the current makeup of the court. Several years ago, there were signs that maybe the US Supreme Court would accept an argument like this one. There was a wonderful dissent in a death penalty case written by Justice Breyer and signed by Justice Ginsburg, where they were inviting this type of argument and observing that the statutory fixes that they had endorsed decades earlier did not work to solve these problems of randomness and arbitrariness and unfairness. So it seemed like there was hope under the 8th Amendment a few years ago. I wouldn't say that anymore, given what's going on in the US Supreme Court. And then, our court had rejected constitutional claims in the past, but we argued that that doesn't matter. Those cases are not stare decisis, because when you have considerable new information, new data, then you have to reconsider the question. Now, so this is something that I know you all deal with, we still deal with regularly. After we filed our brief and filed our statistical report, the prosecutors moved to strike it because it wasn't presented in the trial court. But importantly, the Supreme Court denied that motion, and they denied it for reasons you all understand, but that we're still fighting. Reports and statistical studies are appropriate to cite for the first time on appeal because they are discussing systemic facts, not facts about an individual case. So it's not the type of thing that has to be part of the trial court record. It's something that can be cited just like a law review article or any other secondary source, and then the opposing party can attack it on its merits, but it's not improper for it to be there and to be cited. So the court denied the state's motion to strike, but the state still did not respond to the study on the merits. Didn't in their brief, they just very briefly said again that you shouldn't consider this. And even at oral argument, they kept saying, you can't consider this, you shouldn't consider it, you shouldn't consider it. And I was saying, yes, you should, and just reverse and declare the death penalty unconstitutional. Don't worry about the prosecutors. Well, the court didn't like either of those answers, and instead they gave the state another opportunity to respond to the study after oral argument. They issued this order initiating, and you don't have to read that, that's just an image of the order for no reason whatsoever, but they issued this unprecedented order initiating special proceedings so that the state could hire their own expert, which they could have done before, but they didn't, and evaluate the study and provide a response or a critique. And these special proceedings did not consist of live oral hearings. It was all an exchange of detailed written submissions over the course of a couple of years. And again, Neil and I and Catherine and Heather worked very, very closely during these special proceedings because some of the disputed issues were really more legal in nature and some were more social science related. For instance, Neil and I answered the concerns about why we chose the data set we chose because that was really more of a legal question, whereas Catherine and Heather explained why the data set was large enough to perform a valid regression analysis scientifically. So those are the types of things we were dealing with. At this point, the state finally hired their own expert for the first time. He could not replicate the results of the study and filed a scathing critique claiming there was no problem with race discrimination in the imposition of the death penalty in Washington. But Heather Evans reverse engineered his work and figured out his errors. She really did a brilliant job. Turns out he had dropped a whole bunch of cases from the analysis inadvertently. He later owned up to those mistakes, but still alleged there were problems with our study that rendered it unreliable. For example, he thought the data set was too small. So we went back and forth on these types of issues, and we filed a response to his critique at the end of that first summer, and our researchers still concluded that there was strong evidence of race discrimination in the imposition of the death penalty. So then the commissioner had these dueling reports that she poured over for about 9 months. And then in the summer of 2017, she sent the parties and their experts a set of 35 interrogatories, basically follow-up questions about all of these disputed areas. So again, we got together and produced a response to these interrogatories. And then, in November of 2017, Commissioner Pris issued her report to the court, and this was a 97-page single-spaced report. It did not include an ultimate recommendation on how the court should come out. The report just set out each of the disputed areas, each of the parties' positions, some of the commissioner's own research, and then left it up to the court. So then we filed supplemental briefs in January of 2018, and in our brief, we explained why our study was reliable and why that meant the death penalty was unconstitutional. We also got a good amicus brief. We got good amicus briefs at both stages, but at this stage, we also got an amicus brief from social scientists and statisticians around the country who endorsed the methodology and conclusions of Drs. Beckett and Evans. So I think that was helpful. And then we're back to this, and you know the final result. But in the opinion, the court did place great weight on the Beckett and Evans study, and they agreed with the argument that the death penalty was unequally and unfairly applied, whether you're talking about race or county or just randomness and arbitrariness. And they placed great weight on the study, not just because it had been through the ringer and special proceedings and was proven reliable. Actually, let me back up, sorry. This slide points out something that will be important for us moving forward. So the court found this rigorous regression analysis reliable, but in this portion of the opinion, they also strongly hinted that such a rigorous study would no longer be necessary moving forward. They said they refused to require indisputably true social science, and instead they endorsed the results because they were accurate on a more likely than not basis. And they also said that because of other things like, we had cited the task force report and cases like Monday and Saintcalle and other cases and studies regarding other areas of our justice system and race discrimination in those other areas, the court said, you know what, we take judicial notice of racial bias in our criminal legal system. And this is a key quote that we can use in all sorts of contexts, and I know people have already been using in all sorts of contexts. So our court now takes judicial notice of implicit and overt racial bias against Black defendants in this state. That can be used in any context. Excuse me. Now, the other thing we did, of course, was to argue that the death penalty was contrary to evolving standards of decency. And I know that many of you have made these types of arguments in the juvenile context, for example. So the court looked at trends in other jurisdictions to determine whether the punishment was constitutional. And they noted that local, national, and international trends disfavored capital punishment. So this type of analysis is also important in other contexts. And ultimately, the court struck down the death penalty under Article 1, Section 14. So that's Gregory. But what do we do next? And I know that's really why we're all here. How do we extend the principles of Gregory beyond the death penalty? There are a lot of contexts in which we can do so and are doing so, but the most obvious next step is to address what is now the harshest penalty in Washington, which is life in prison without the possibility of parole. Now, the Korematsu Center at Seattle University urged me not to call it that and instead to call it a death in prison sentence, which I think makes sense. That's more accurate for what it is. When I'm comparing it to the death penalty, I don't do that because it gets confusing, but now, henceforth, I will try to refer to it as a death in prison sentence. Forgive me when I don't. Well, shortly after Gregory, the next year, the court decided State versus Moretti, and that was actually 3 consolidated cases handled by 3 wonderful OPD appellate attorneys, Maureen Sear, Catherine Russell-Seck, Susan Gash, who we all miss very much, I'm sure. In this case, the court did reject the argument that this 3 strikes law could not be applied to people who committed strikes as very young adults. But Justice Yu wrote a really important concurring opinion that some of you may remember. And just like Justice Wiggins's dissent in Davis, Justice Yu's concurrence in Moretti was a really important one to read for its call to action regarding arguments that should be made against the 3 strikes law. In any event, Justice Yu pointed out that after Gregory, the harshest penalty in Washington is now death in prison, or LWOP, and that now people convicted of multiple aggravated murders have the same sentence as people convicted of, say, 3 assault twos under the 3 strikes law. And that should raise huge concerns about disproportionality, right? In Gregory, we had argued that in addition to this racial bias problem, there was a problem of disproportionality where you have someone like Mr. Gregory with 1 murder and no violent felonies sentenced to death, while dozens of people with multiple aggravated murders and violent histories were serving LWOP. So similarly here, Justice Yu is saying, we might have a disproportionality problem with aggravated murders serving the same sentence as those with multiple assaults and robberies. And then she also said, there might be problems with racial bias in this context, just like there was with the death penalty. And she very explicitly set out the arguments that we all should be making, or that she wants us to make. Is LWOP fairly applied? Is there a disproportionate impact on minority populations? Are there state constitutional limitations to such a question? So she's inviting us to make these arguments. And that's what we're doing, obviously. Now, the whole court issued a call to action following Derek Chauvin's murder of George Floyd. And you all know this, and you've all quoted this letter multiple times, and we need to continue doing that. The court issued this broad call to action for lawyers and courts to address systemic racism. And it's up to us to consider the precise legal hooks to make it happen in each context. Also, Catherine Beckett and Heather Evans did not stop the analysis with the death penalty. They issued a report for the ACLU a couple of years ago in which they studied life and long sentences. And not surprisingly, they found that these sentences have been imposed in a racially disproportionate manner and noted they did not comport with evolving standards of decency. And you can find this report on the ACLU of Washington's website. It's a good report. They don't break it down by sentence type. They lump all long and life sentences together. So they evaluate long sentences imposed under the 3 strikes law, the 2 strikes law, aggravated murder convictions, multiple enhancements, multiple aggravating factors, and so forth. But what they found is when you look at all of these sentences as a whole, there are big problems with racial disproportionality and inconsistency with what the rest of the world is doing. Now, there have been some reports focused specifically on the 3 strikes law, but they are very old. One was this 2009 report by Columbia Legal Services. And it's a report that oddly the courts are still citing as if it's current, but it is from way back in 2009. So it only covers about half of the lifespan of the 3 strikes law. This report found that back then, about 53% of persons subject to the law are people of color, even though they only made up 25% of the population, and about 40% of persons subject to the law are Black, even though they make up only about 4% of the population. So that's obviously alarming. And the Sentencing Guidelines Commission found the same thing. Both of these reports were based on the same data, of course. And they released a report the same year, finding the same thing. So again, this is really troubling, but it's old. We've had 13 more years of data since then, plus Rob 2 is no longer a strike, and that has to be accounted for in any current analysis. So these are the things I was thinking about when I was assigned to Raymond Brown's case this spring. And actually, I should note that I started thinking more carefully about these issues about a year ago, thanks to Jody Backlund reaching out to me and connecting me with a former client of hers who was thinking about these issues, an incarcerated person who was thinking about these issues. And so I spoke to him and I spoke to Jody, and then I also reached out to Andrea Burkhart because of work she had done on that 3 strikes case a year ago, State versus Smith. So again, this collaboration across offices with our fellow OPD appellate contractors is super helpful. And I want to thank all of those people who've done this work and have been willing to discuss the issues. So I was appointed to represent Mr. Brown, I don't know, back I guess at the beginning of the year or so. Mr. Brown was sentenced to die in prison for a third strike of second-degree assault. It was just the reckless infliction of substantial bodily harm kind of assault, not that he was acquitted of deadly weapon. So it was just a single punch to the mouth and a little fracture here. Again, not minimizing the pain to the victim, just pointing out that this crime resulted in death in prison, just like multiple aggravated murders. And when I was assigned to Mr. Brown's case, he's also a Black man, if I didn't say so. And when I was assigned to his case, I wanted to challenge it as both unconstitutionally racially disproportionate and unconstitutionally disproportionate to the crimes. Both of these issues are questions Justice Yu asked in her concurring opinion in Moretti, right? She said, we just struck down the death penalty because of racial bias problems. Is this law also unconstitutional because of racial disproportionality? And she also said, might it be problematic that with the end of the death penalty, people who commit aggravated murder get the same sentence as people who commit multiple assaults? And these are important questions that she quite properly asked. And either of those problems on its own should be a basis for invalidating a sentence under our cruel punishment clause. But certainly both problems together should be. So what did I do? Well, first of all, what did I not do? I did not commission a statistical study by social scientists. I did not commission a regression analysis like I did in Gregory. And I'd be surprised if somebody does that, though by all means try if you want to. There are two reasons I didn't do it. First of all, it's probably not necessary in light of our Supreme Court's repeated recognition that racial bias permeates Washington's criminal justice system. Remember, they said in Gregory itself that they do not require indisputably true social science. And they said in Gregory that they take judicial notice of racial bias in our system. So that's good. And it's especially good because it's probably not possible, or at least it would be extremely difficult to do a regression analysis of the three strikes law, because you'd have to gather the relevant data at each of the decision points, each of the decisions to charge a strike offense versus a non-strike offense, and for everyone else to charge a non-strike offense, and so forth. So I'm hoping our court would be willing to act based on a straight up disproportionality analysis, especially given how stark the numbers are. Still, we can't just use the reports that are already out there, because that 2009 CLS report and 2009 SGC report, while great, are very, very old. They only cover half the lifespan of the three strikes law, which makes them really under-inclusive. But then they're also over-inclusive in that they include cases where Rob 2 was a strike, which, as you all know, was removed, and that's retroactive. So I asked around to see if anyone had current reports like these CLS and SGC reports, and it didn't seem like anyone did. So I just went ahead and built a report myself by entering data into an Excel spreadsheet one weekend. And the data that I got was the same source data that was used in that CLS report and that SGC report, namely data from the Caseload Forecast Council. And I know that some of you have used data from this website in your own arguments in either the same context or other contexts. It really is a great resource. So the Caseload Forecast Council has these annual reports called Statistical Summaries of Adult Felony Sentencing, going all the way back to 1999. And what I did was to open each one of them and then enter the relevant information into a spreadsheet. And this is what it looked like. This is the kind of data they collect, and they have pages and pages and pages and pages and pages that look like this, where they show individual cases in each county for each year, and they list the current offense and the prior strikes and the race and the age. Age wasn't always tracked. which makes it harder if you want to evaluate that variable. But thankfully, these reports do at least list the crimes and the race of the defendant. So I opened all of these reports for each year and just entered the data into the spreadsheet and then did some sorting and filtering and graphing of the relevant data. So here's just a snapshot of a tiny portion of the spreadsheet. And in addition to tracking race and offenses, you can see that I specifically tracked whether one of the strikes had been robbed too, so that I could remove those later. And I also tracked whether one of the strikes was an assault too, because I wanted to analyze the data independently for assault 2 strikes, given that that was my client's most recent strike, and it's one of the least bad crimes remaining in the strike list. I guess I'll put it that way. And what I found was that if you go up through 2021, it was pretty much just like the data through 2008. Black people still made up 40 to 41% of 3 strikes defendants. So that didn't change in the second half of the law's lifespan. And eliminating Rob 2 as a strike did not fix this problem. There were some rumblings, apparently, Andrea said, from prosecutors that they thought the removal of Rob 2 fixed the racial disproportionality problem. It did not. It slightly reduced the Black share, but not by much. It got it down to 37%. So after filtering out the Rob 2s, I determined that Black defendants, at least, are still extraordinarily overrepresented in the 3 strikes population relative to their share of the Washington state population. And I just imported some current census data as well to use in these comparative bar charts. So you can see the blue bars represent the share of the Washington population. And for that one, Black defendants represent just 4.4% of our population. And the orange bar represents the share of remaining 3 strikes defendants. And for that, as I said, Black people make up a 37% share. So you can see the huge difference. I guess my little cursor's not showing up there, but you can see it. The one labeled Black has the huge difference between share of the population and share of the 3 strikes population. And then I did the same thing separately, limiting the data set to people with assault 2 strikes. And that was slightly worse for Black defendants. Black defendants made up 38% of that population. Now also, of course, you want to look into disproportionality to the offense. So not only is this law imposed in an incredibly racially disproportionate manner, but the punishment is disproportionate to the offense and disproportionate to punishments in other jurisdictions. Now, as I said, so I guess I didn't say this actually, Andrea Burkhart had gathered all of the persistent offender statutes from other jurisdictions for a case she handled. Jody and Monique had done the same thing in Witherspoon. So again, I built on their great work. And in fact, I just used the list that Andrea had in the recent Smith case. And I credited her for that work in my Brown brief, or in the actual appendix where I put it. And then I just drilled down to each of the relevant statutes to see how they handled assault too, because that's not an issue that Andrea had. And what I determined was that no other state imposes LWOP, or death in prison, for a 3rd strike of 2nd-degree assault. And that's specifically the reckless infliction of substantial bodily harm type of assault. There were some others that counted the type of assault with a deadly weapon. This is very nitty gritty, and you'll only have to worry about that if you're dealing with an assault too. But this is the kind of thing you want to do, of course, if you're making these arguments. So I think I was careful. I hope I'm right. I don't think any other state imposes LWOP for an assault 2 strike, at least not any of the states that have 3 strikes laws. So in Washington, we do impose life without parole or death in prison. A person in Washington could receive death in prison theoretically for 3 assault twos, which again is the same sentence a person could receive for 3 aggravated murders. So this law is both racially disproportionate and disproportionate to the crime, at least if you've got an assault 2 strike. Sorry, I already said that. So that's the relevant data on racial disproportionality and the relevant data with respect to disproportionate punishments for the crime. So obviously what we want to do with that data is to argue that a death in prison sentence for a 3rd strike violates Article 1, Section 14. Now, as you all know, for better or for worse, our court has not settled on a single approach to cruel punishment claims. So we want to cover our bases and argue Gregory and Bassett and Fain, right? And those are 3 slightly different frameworks. They're not that different from one another, but they're slightly different. And I think it's best to argue them all. And that's what I did in the Brown brief. And by the way, I'll send my Brown brief to Gideon so that you can get the nitty-gritty details of each argument and copy them in your own cases if you want to. But there is a lot of overlap among these arguments, so it's not that complicated. And I do think it's important for us to argue each one because some justices or judges favor one approach, others think that a different approach is more appropriate. We saw that, for example, in Bassett, where the majority addressed the claim under both frameworks, and the dissent said only one of them was appropriate, and so forth. So we want to give them the options. And so for each of these arguments, I made the argument as to the 3 strike statute as a whole, and then specifically at a minimum as to those with assault 2 strikes. So it was unconstitutional as administered under Gregory because it's imposed in a racially disproportionate manner and does not comport with evolving standards of decency. That's true of the whole statute, or at a minimum, it's true for those with assault 2 strikes. Categorically unconstitutional under Bassett. You know all of these factors. Contrary to the national consensus, disproportionate to the culpability of the offender, and inconsistent with legitimate penological goals. And again, as to the whole statute, or at a minimum, as to those with assault 2 strikes. And then finally, argued under Fain. And when I made the argument under Fain, and it's up to you whether you think this is appropriate, you may also want to make an argument as applied to your client's specific case only. That's what the dissent in Witherspoon did. And it makes sense to do so if you have a good constellation of facts. So because Mr. Brown's 3rd strike was a mere reckless assault 2, and his 2 other strikes resulted in 0 bodily injury, and he's a Black man subject to a law that's imposed in an extremely racially disproportionate manner, my argument was, at the very, very least, on his specific constellation of facts, this sentence was unconstitutionally cruel under Fain. And so for each of these arguments, I included charts and graphs from my spreadsheet within the body of my brief, but then I also attached an appendix with the entire spreadsheet and a declaration explaining exactly what I did, where I got the data and what I did with it in Excel. And I think it's important to have that for full transparency. But what happened is it didn't get beyond that because the state didn't file a response brief. This was Spokane County, if I didn't say so. Instead, they offered to settle the case, and we have settled it now. So Mr. Brown originally had 6 convictions in this case, including that 3rd strike, and he had an offender score of 10. They offered to settle the case and have him plead to 2 counts, no strike offenses, leaving him with an offender score of 5 and an agreed high-end sentence of 48 months. And we did have the resentencing hearing at the end of August. And so the appeal has been dismissed and Mr. Brown will be released imminently because he's already served the 48 months when you include his good time. So that's all great for Mr. Brown, but what does everyone else do now? Well, basically, it is fine with me if you just copy my Brown brief and reuse the relevant portions of that brief and attach that appendix to your own briefs. And a couple of my colleagues have already done that, and they're working through the state's responses now. And when you do that, if you decide to do that, it will be very, very helpful, we think, if you drop a footnote explaining what the prosecutors in Brown did when they saw these arguments and the data, because even though you can't say so explicitly, this settlement offer is an implicit acknowledgement of the validity of the data and the arguments. And I think the Court of Appeals will understand that and understand that this implicit concession even may have particular force because it comes from the Spokane County Prosecutor's Office, which is one of the more draconian offices in the state normally. So that's what folks in my office are doing. They're copying the arguments to the extent they work for their clients, attaching the appendix, dropping this footnote saying, by the way, at least one prosecutor's office understands that this is probably correct. And then we'll see where it goes from there. Not surprisingly, the Pierce County Prosecuting Attorney's Office has not offered to settle the cases where my colleagues have raised this argument. And in fact, they've moved to strike all of the Brown appendix from my colleagues' briefs. So they're dealing with that right now, but somebody's going to accept the data and the arguments at some time, hopefully. That's the desire. Maybe they won't, maybe we'll go into a backlash period and it won't happen, but we've got to try. And then obviously in the meantime, make other arguments. I know so many of you, including some folks in my office, are still challenging the use of juvenile strikes. Hopefully someday our court will address that. And then I also know some of you do a lot of legislative lobbying, which I appreciate. I don't do that. It's important. It's a lot of work. It's important to try to convince other decision makers in other branches at the same time we're litigating these issues in the court. So we can keep lobbying the legislature to remove more and more crimes from the strike list, including removing juvenile strikes and hopefully assault 2 strikes. But that's Brown, that's 3 strikes. And oh, here's the footnote. I can send this to you, Gideon, to send out, but this is the one that we've been using in our briefs, demonstrating that the Spokane County prosecutors at least have decided to settle a case instead of responding to these arguments. So that's all that I have. And I do again want to thank people like Andrea and Jody who discussed these issues with me and who have worked so hard on these issues. And I hope we can all see each other in person someday, but thank you, Gideon and OPD, for setting up these virtual meetups in the meantime.
Well, thank you so much, Lila. I think we have some time for questions. If anyone has any questions for Lila.
I have a question. Can you hear me okay?
Yeah, go ahead.
Okay. Lila, or anyone else, are you aware of any cases in the pipeline right now where a similar argument has been made for an LWOP sentence from an aggravated murder conviction?
That's a good question. I am not. Anyone else?
Well, it looks like I might be the first of mine then. I have one right now where I'm planning on making this type of argument. A follow-up question, Lila, in terms of a Beckett-like study, you mentioned how it would be impossible or at least extremely difficult to do that for a 3 strikes case. It seems perhaps more likely to be done in an aggravated murder case in terms of its feasibility to do that type of regression analysis. What do you think?
Well, maybe. I mean, if you would like to figure out how, that would be wonderful, and then we can all learn from you. You know, the reason it was, I don't want to say easy because the whole process took 6 years and it was incredibly grueling and difficult, but the reason it was relatively easy to do the study in Gregory is because there was that ready-made data set of the aggravated murder reports. And so we could isolate the decision to impose the death penalty or impose life without parole because we had the whole data set for that. But what we couldn't do, and what I think you would need to evaluate what you want to evaluate, is evaluate the earlier decision point to charge aggravated murder versus first-degree murder or second-degree murder or, you know, manslaughter. Because the data set that we had that was gathered for proportionality review would not have captured that earlier decision point. So if you want to do some type of regression analysis, whether of aggravated murders or 3 strikes, you won't have a data set. You'll have to gather the data, and it will have to be the right data to evaluate the relevant decision point, right? Which is the decision to charge aggravated murder instead of some other murder. So you need not just the set of people charged with and convicted of aggravated murder, but all of these other people who were charged with, say, first-degree murder, second-degree murder, et cetera, some other type of homicide. And then you'll have to evaluate and compare the facts of the crimes to see if, you know, the charging decisions made sense because of the facts of the crime, or if instead they're, you know, you can isolate race as a factor in those decisions. So it seems like you'd have to gather data for like all homicides, and then evaluate the charging decisions. And you know, as Gideon pointed out to me when he saw these slides, he's like, well, maybe it's not as hard as you think, because you could say isolate it to a single county instead of trying to analyze the whole state's practices. And I think that's a valid suggestion. So you could try to just limit it to a county or limit it in some other way to make it a little bit more feasible. But these are the types of things you have to think about, right? So we were lucky in that we had a data set that enabled us to evaluate a couple of decision points. And then it was still really hard, even with that. So that's why I'm hoping that we can just convince them with this straight disproportionality analysis, especially since the disparity is so stark. I'm hoping it will be enough, but you know, it may well not be, because technically somebody could validly say, well, that's not the whole picture. You have to isolate the variables and determine whether it wasn't just based on, you know, some valid factors. Anyway,
Yeah,
is that helpful, or is that, I mean, what do you think, Casey?
No, that is very helpful. That's something I've been struggling with, and just trying to figure out what kind of data would be needed when applied to an aggravated murder case or a 3 strikes case. I had this Davy Kennan case from last year where the Division I in an unpublished decision rejected my racial proportionality argument on a 3 strikes case. And basically they said, well, yeah, there's lots of racism throughout the system, but you don't have a Beckett analysis, so pound sand. And ever since then, I've been thinking, well, you know, what more can be done in terms of giving them the data? But for the 3 strikes situation, it's very helpful for me to hear that you have taken some additional steps to bolster the stats. So that's great. Thank you.
Yeah, thanks, Casey. And that's interesting. I'll try to find the opinion you're talking about.
yeah, I mean, if people aren't aware, you know, the Beckett analysis cost, I don't know, $30,000, $40,000, $50,000, took a long time. The reason it's so complicated is because the data had to be hand coded, right? We had these trial reports, but then they had to go through, case by case and kind of characterize it in a way that could be statistically analyzed, right, Lila?
Well, right, but that was me doing a lot of that, so you didn't pay me any extra for it. They had to do they had to do the stuff that we didn't understand, like actually putting in and creating the models and putting it into their models and all of that. And actually, the reason it ended up costing as much as it did was not because of the initial study, it's because of those special proceedings that the Supreme Court ordered. And you guys ended up paying me and Neil and Catherine and Heather a lot more than originally anticipated because the Supreme Court ordered us to do those special proceedings. So of course you weren't going to say, well, no, we're not going to pay you, although I guess you could have. So thank you for not saying that and for paying for all of it. But just to be clear, the initial study did not cost that much. I think it was 16,900 or something like that, which isn't nothing. But the reason it cost so much more than that was because the court ordered special proceedings.
Yeah. In the unique situation of the death penalty meant there was extra funding available. And also the court was just going to give us a lot more time, or going to give the parties a lot more time to litigate than they will in a non-death penalty case. So a Beckett analysis, I mean, Lila's absolutely right. It'd be very difficult to do for, and like the death penalty, it's a limited data set. You could literally pull in every single death penalty case since, whatever, I don't know the original date, but for the last few decades, you could get them all and analyze them all. And it's not an insurmountable task because there's not thousands and thousands, right? Once you start expanding out to not only every aggravated murder, but every case that maybe could have been an aggravated murder but wasn't, then you start to get kind of mind-boggling. And again, it would need to be hand-coded. You're not going to be able to have a machine that analyzes the facts of the case to say, meaningful things about it for an analysis.
Hey, Lila. I was wondering, can you hear me? This is Anne. Hi.
Yeah.
I am wondering if the data that you prepared for the Brown brief, Spokane County, the prosecuting attorney didn't just accepted that. So Pierce County is the only one who's challenging that data.
So far, so in my office, those are the only counties we've dealt with because, I filed the Brown brief at the end of May and then they reached out to me in the middle of the summer offering to settle and we just wrapped up the resentencing. So it just happened. And Devin and Jessica have copied the arguments and attached my appendix to their briefs, but both of their cases are in Pierce County. And I assume you guys all know that Pam Leginsky is now with Pierce County Prosecuting Attorney's Office. So she moved to strike all of it in Jessica's case. And then a little while later, Ann Eagler moved to strike it in Devin's case, even though Devin's case predated Jessica's. So they now have their office strategy on this, and it's not surprising, but who knows what will happen in other counties.
Right. So maybe if it goes through a rigorous process for validation or whatever they do in the courts, that then it will be like the Gregory report, just considered trusted and correct and accurate and be used all the time without challenge.
Well, that's a good point. One of the arguments that Ann Eagler made, and maybe Pam made this too, I just skimmed the Ann Eagler motion that Devin got, is that, at worst, you need to do what they did in Gregory and subject this to some type of review. And, all of that is silly because this isn't a complex regression analysis. It's literally something anyone could do. You just sit down. It's just, it's a mundane, mind-numbing task. that requires some legal knowledge, but it's really just data entry. And then knowing how to use the sort and filter features in Excel and the chart and graph features in Excel. But it all comes from the Caseload Forecast Council. That's the data source. And anyone can just go do it, right?
Right.
So it doesn't, there's no expertise necessary because, like as Casey and Gideon and I have been discussing, it's not a regression analysis. It's just a straight disproportionality analysis. It's all taken from the Caseload Forecast Council. So it's just entering data into an Excel spreadsheet, sorting it, filtering it, etc. And so, sure, I think judges or clerks or prosecutors should double check the work and make sure I didn't make any errors, but anyone can do that. And I don't think a court needs to order it. They can just do it when they evaluate the case. It's nothing like a complex regression analysis, right? So,
Right.
so sure, they should evaluate it. They should make sure I didn't make some mistakes. But honestly, even if I made a couple tiny errors, it's not going to change the big picture, right?
Got it. Thank you.
Yeah.
Could you go ahead and stop the recording for us, Debbie?